State of Michigan versus James, SX 362-68561. I held you in contempt of court. Um, 24000007. State your name for the record, please.
I am James Garner, the living man, not the corporate fiction that y'all alleging these charges against.
You got to come down and appear in person, sir.
And I have no problem with that. As soon as the prosecutor can provide me with jurisdiction, an affidavit of an injured party, and a sworn affidavit from someone named the people of the state of Michigan. Because
you will get nothing and like it.
Because under the law, all of those things must be intact for me to even answer these alleged charges. The court has no jurisdiction. They have not shown any jurisdiction. They have not presented me with any jurisdiction or a contract saying that they have jurisdiction.
All right. Well, before we even get into that, you have to come down. Mr. Garner, you have to come down in person, all right?
We did that, and that didn't work out so good. Okay, well, here's the thing, Mr. Perkins. Unless the court can provide me with a sworn affidavit under oath, as the law requires, of an injured party, there is no case. In order for a case to exist, there must be an injured party. The law says it is the rule of law. And unless the court is trying to violate their oath of office and commit perjury, you don't understand what the problem is.
All right, I'm gonna mute you, sir. Come on down. Make your way out.
The law clearly states.
Let's pass that matter.
The law clearly states there must be an injured party for a case to exist. Now, if the prosecutor.
All right.
All right. I need to give a shout out to Law Nerds Unite. Zach got that over to me this morning. I don't know if he's going to come back or not. It's not clear to me from this clip. I've got more. This is from Brecken.
iPhone that I'm trying to name. Can you unmute yourself, sir, and state your name, please?
Bradley Graham.
Good morning to you.
Good morning.
Okay. The city of Detroit versus Bradley Graham. Page number C8. Oh, wait a minute. Get the probation officer down here for this one. Yeah. Who is Des? Des. Unmute yourself. I'm going to get the probation officer down here, Mr. Brown.
Okay.
Let's go call the city of Detroit versus Bradley Graham III. Case number Z8093641. Appearance for the record, please. State your name for the record, Mr. Graham, please.
Bradley Graham.
All right. Ms. Bumpus, good morning to you. Can you state your name and your title for the record, please?
Yes, good morning, Your Honor, and to all your staff. Lori Bumpus on behalf of the Probation Department.
All right, so let's find out what's going on with Mr. Brown.
Yes, Your Honor. In this case, Mr. Graham was placed on probation February 14th of 2025 for a period of 6 months. This is actually supposed to be his discharge date, Your Honor. However, at this time, he still owes a balance of $630. In addition to that, Your Honor, the defendant failed to test as scheduled for July. He failed to test July 7th and then again on July 19th. They have him as scheduled also for August the 8th. They don't have it officially, but it appears he did not report on that date as well. He has completed alcohol highway safety education. He has completed the victims impact panel, and he's also completed the consequences video.
Mr. Let's talk about the test, sir. What's going on with the test?
It's not really nothing real major. It's just my job haven't been working, so I haven't been able to pay for it.
Well, it's something major because we don't know whether you've been drinking or not.
Yeah, that's true. But it's like this, like the company I work for, if Chrysler going
There is that.
to shut down, we automatically shut down. So it messes up our pay. You get where I'm going?
But did you talk to Ms. Bumpus about this?
I just talked to her
When?
yesterday. I called her because I was supposed to report back to her, and she didn't respond. So I left a
Yes,
voice.
we talking about July. This is July. This is already in August. This is over a month.
Yes,
You don't wait till. Wait a
I was
minute.
supposed to see her in July.
Hold on a
That's what I'm
second.
saying. I was supposed
Hold
to.
on a second. Hold on a second. You do not wait until the day before you go to court to call somebody when you have an issue like that.
I didn't wait till I was supposed to report to her in July. That's what I'm trying to say. I left a voicemail and she didn't respond. I guess she didn't get through, her thing probably was full or something.
Listen, the thing is, like, what I'm trying to say is, you just told me that she called you, that you called her yesterday.
No, she
About-
called me yesterday. I called her in July.
Okay. When did you call her in July?
The day of that I was supposed to report to,
And you only call her one time?
and left a voicemail.
Did you call the other times you missed the test?
No, I didn't, because the times that I missed the test, it was around the time that I had to report, so I was going to tell her it all at one time.
Don't do that next time, please.
Yes, sir.
Are you working now?
Yes, sir. We just really started back working last week, like full weeks.
When is the last time you tested, Ms. Bumpus?
June 28th, Your Honor.
June 28th?
That's correct. Your Honor, for the record, we had previously done a probation violation. That was his last hearing, May 15th, for the same thing, for missing tests.
You're gonna tell me it's for the same reason?
Yes, Your Honor. In addition, I talked to Mr. Graham, and he knows that he can come here and test if it's financially a problem, but he said it's too far for him to come here. So that's been his statement when it came to testing. I've offered that to him and he still hasn't done that. So I don't know what to say.
Is that true? Mr. Graham,
Huh?
is that true?
She said that she offered me that. I can't remember offering to come down there to her. She just told me I need to pay in advance when I go
No,
to.
you don't remember telling her that she was too far to come down here?
Oh yeah, no, I don't remember her saying I could come down there to where she's at and test.
You don't remember you telling her that it's too far to come down here?
No, where I'm at is where it's close to my job at. I cannot drive.
Listen, I didn't ask you that. I asked you a question.
I just said I don't remember that. You keep saying I just said it like 3 times. I said I don't remember her telling me nothing about coming down there and test where she at.
I asked you a specific question.
What's this changing actives nonsense? I mean, it's hilarious, but I don't get it.
Now listen to my question. You don't remember telling her that that is too far to come down there. Do you remember saying that to her?
I do not remember saying that to her.
And when did you start back working?
Just last week, a full week. We have been working, but it's been 1 or 2 days, and I get stuff took out of my check for child support, so I never have no money on my check.
Well, you need to come down here today and test. That's what we're gonna do.
I have to
Come
work. I can't just come down there, and I have no transportation. It doesn't.
Listen,
That's why I be trying to explain to you guys.
Listen, I can't solve all your problems for you. I need to
I
know.
never asked you to. I told her exactly what's going on.
All right, you're not listening to me. You gotta come down
It's
here
like y'all
today.
going way past what I keep trying to explain to y'all, and y'all just telling me to do a certain thing. If I don't have the money to do it, how you want me to test something?
Ms. Beltran has
That don't even make sense. It's like you keep telling me that.
All right, I'm not gonna keep going back and forth with you, sir. You're gonna have to come down here today and test. That's all it is to it.
I can make it tomorrow if it's possible. I can make it tomorrow, but today I cannot. I have to go to work in a second. I don't have transportation. It just can't just pop up like that for me. I'm all the way out far. I can't just drive. I can't just do that.
Wait a minute, Mr. Graham. You gotta understand, you better watch your mouth, first of all. You don't tell me what I can just pop up and do, okay? You're the one that pled guilty to drunk driving. It's my job to make sure that the roads are safe and you're not out here drinking. So you ask, don't tell me what I can do.
Yes, sir.
That's how this works. All right, so come down tomorrow morning and you're gonna test. And Ms. Bumpus, let me know what the test is. If there's anything in your system alcohol related, then we're gonna have a problem, okay?
Yes, sir.
All right, come tomorrow morning. Review tomorrow morning at 8:25.
Okay.
Have a good day.
Thank you, Your Honor.
You're welcome. Let's go back on the record with Mr. Eric Grant. Garrett. Mr. Garrett, I'll give you an opportunity to speak to the case. So counsel, what's your client want to do? Ms. Soroki?
Yeah, Your Honor, the people have made an offer to my client. He wishes to avail himself of that.
What is that all?
Mr. Garrett, his open alcohol is being amended to passenger. He's going to plead to that. Everything else is being dismissed.
You want to take the deal, sir?
Yes, sir.
Can you raise your right hand, please? Swear or affirm, tell the truth, whole truth, nothing but the truth.
Yes.
Or you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Ms. Soroki went over your other advice about you break out. Did she not?
Yes.
You understood those rights?
Yes.
You have any questions about those rights?
No, Your Honor.
You know, by taking the deal, you're going to give those rights up?
Yes.
Has anybody offered you anything other than what's stated in the record?
No, Your Honor.
Are you the type that just runs red lights, sir?
No, sir.
You ran them on this day, didn't you?
Yes.
And you ran 2 red lights, right?
No, just one.
So what was the purpose of that?
What was the purpose of it?
Yes.
Overreacting, really.
Because you're the one that just runs red lights. You just go through them. When you see them, you don't even stop.
No, that wasn't the case. That's not something I practice.
Run his driver's license. All right. Let me draw your attention back to June the 23rd, 2025, around 8:39 p.m. in the city of Detroit, in the area of Joy Road and Grand River. Did you have an occasion on that day to come encounter with the Detroit Police Department?
Yes, sir.
Did you have some, were you in a motor vehicle?
Yes,
Did you have some alcohol in that motor vehicle?
yes.
What kind of alcohol did you have?
Beer.
What kind of beer was it?
That was Coors and Stella Altos.
Was it open?
Yes.
So was it some in the container?
Excuse me?
Was it some still in the container?
I believe so.
You have to know so, sir. Was there some alcohol in there or not?
It was the passenger. I don't. Yes, it was some alcohol in it.
Seems like he's about to tell me that the passenger had some alcohol. He doesn't know whether there was any in the container or not. What is it, sir?
What do you mean? You asked me, was it some alcohol, open alcohol in the car, right? Was it alcohol?
Wow, you didn't sound too sure. You said it was the passenger, almost as if you didn't know. Was there any in the
But I don't know what he had in his. They had him pour it out.
What did you have in yours?
Nothing. Mine was empty.
You don't know whether there was any alcohol in this container, right?
And who container?
In your passenger's container.
I guess it was.
It's gotta be,
Yes.
it's gotta be some alcohol in that car and it's gotta be open for me to accept this deal. Now, if you don't want to accept responsibility or if you don't know or what, we'll set a trial date.
Yes, Your Honor.
Guess what?
It was some alcohol. It was some alcohol in the container.
All right, find him guilty to the amended count of open alcohol in motor vehicle passenger. If they could probable cause will dismiss the other matters.
So stipulated, Your Honor.
All right, the $240, when can you pay it?
The 3rd.
Pay it by September 5th, 2025. Pay it at any div that kiosk in the city of Detroit. I'm told you can upload the div that app to your phone, or you pay it and come down to court and pay it in person. If you don't have any further questions, sir, I wish you the best of luck. Have a very good rest of your day.
Thank you, Your Honor.
Okay, today was the date that was scheduled for sentencing, but I also have a bond violation that needs to be arraigned on. I have here a complaint of conditional release. The allegations of that on or about the 8th of August at 2:09. Now, Mr. Ray violated the conditions of his bond by being in contact with the protected party.
Your Honor?
Yes.
Did you say that on the 8th? The only information I heard is from the 4th of August.
I'm sorry, we received it. It should have been let me double check. I think we received it the 8th. August 4th is what I have. So you do have that report.
I only have a complaint of violation. I don't have anything further.
That's true for the people as well, Your Honor. At this time, the people would request an adjournment because we don't have a police report on this yet, so.
An adjournment of what?
Well,
This is an arraignment for it.
Oh, and not the hearing?
Yes,
Then we don't need an adjournment.
exactly. Okay.
My apologies.
No worries.
I thought there
Okay.
was hearing date.
Nope, I just received it, so I had to review it. The report alleges that on or about, again, August 4th at 2:09 at the area of 314 Westmoreland Avenue, that police were called or dispatched because the allegation is that the victim stated that Mr. Ray arrived to the location of the address where she's staying or where she was and walked inside she called the police and that he allegedly took off running. Which should easily be verifiable because you were in a GPS tagging, is that correct? Oh, you're not?
Yes, that's correct, Your Honor. I believe it was removed as part of the Leon. Domestic was.
I'm looking for my notes, but guilty on the 29th to attempted IRL. I don't understand why, you all dropped the domestic violence? It doesn't sound like the protected parties over there.
Look. Make sure. It does look like the domestic violence file is closed, Your Honor.
That was for a plea agreement without
Yes,
discussion from the victim? Because why would she be calling the police for, under the understanding that she has a protective order if she was notified that you and agreed with the dismissal?
right. We wouldn't have done that without talking to the victim, so I'm a bit confused.
I don't know if you wouldn't have, you shouldn't have. I can't say that you wouldn't have.
I shouldn't have, so I don't believe that I would have, but
Because she would not have been subpoenaed to a exam.
let's see. If I could.
Yes.
That was a day I believe Mr. Martinez was also here. And there was some discussion with him and I back and forth. I think this was something that he signed off on.
That doesn't mean that that the victim was not properly.
I understand.
That would
Consulted.
explain why I would be a little confused if you and Joel were having those conversations while I was on the record, because I'm not seeing. Where it's from.
Even at the time of the arraignment, it looks like there was a bond recommendation that had 1, 2, 3, 4, 5, 6, 7 complaints of assault or harassing police reports saying victim. So I don't know why Joel decided to dismiss the domestic violence at a preliminary examination where this witness would not have been ordered because it was a preliminary examination on assault. Well, maybe she was supposed to be here. Did she fail to appear? Is that where your notes reflect, counsel?
Yes, Your Honor, I just see that note now for the first time on May 29th, 2025, that she failed to appear.
Yeah.
And I also have the note here that Joel was supervising that was correct.
Thank you. So I'm not proceeding on the PA 53 because you dismissed the charge. However, he was advised that the people have the right to reissue the charge against you. Did you recognize that? That the people have the right to reissue the assault with a dangerous weapon against you? And that by showing up after the court hearing might prompt them and should prompt them to reissue the charge against you? Do you understand that? Do you want to face an assault with a dangerous weapon? Okay, there's a sentencing that's scheduled for today. Do you have a free copy of the pre-sentence report, counsel?
Yes, Your Honor.
Yes, Your Honor.
Is there need to make corrections, updates, or deletions?
No, Your Honor, that's what we saw when we were reviewing it now.
Nothing on behalf of the people.
You can make allocation.
Thank you, Your Honor. Based on the plea agreement in this case and based on the pre-sentence investigation report that was completed, I believe we would ask that Mr. Ray be allowed the opportunity to have a term of probation with this court with appropriate conditions. He is at this time full-time employed with Meyer. He in fact has to work later today when we were discussing the issue with the PA 53 allegations. He indicated that he had worked later this afternoon. He had been trying to keep his life on a more positive trajectory. Allegation from early August being an allegation, not proven. So I'd ask the court to allow the opportunity on probation to keep himself employed and to improve himself on term of probation. Thank you.
I didn't participate in the plea negotiation. I recognize that the victim failed to appear, but it doesn't sound like the victim is disinterested in at least some level of protection if she's calling the police because of her belief that this individual was present at her address. But what I do know is as I review your criminal history, I'm disgusted. You understand that? Do you speak?
Yes, ma'am.
Do you understand that?
Yes, ma'am.
Do you know why I'm disgusted? Tell me why I'm disgusted looking at your prior criminal history.
I'll answer you to me.
Not just between you and her.
Behavior in this case is disgusting.
You're what, 19 going on 20? And all I see is a ton of assaultive interactions, not just with her. We got assaults or attempted assaults on police officers. There's 7 police reports that name you as a subject allegedly assaulting a young lady. 7 police reports. 7. Even in the case that you have here today, there was a serious felony alleging that you assaulted her with a dangerous weapon. It was dismissed on a technicality, meaning she did not appear in court. I don't know why she didn't appear in court. I don't know if she was threatened and that's why she didn't appear in court. I don't know if she didn't get her subpoena and that's why she didn't appear in court. What I do know is that where there is smoke, there is fire. No one has this amount of interaction with the court for assaultive actions and then they're not violent. Whatever you're dealing with, now is not your time to speak. It's my turn. Whatever you're dealing with that makes you think that when you don't like the way something is going or the way things are being said or the way things are being handled, that you can use force, you need to get it under wraps because you're in a dangerous cycle. You're going to end up dead or in prison. Do you understand that? You are too young. I'm ordering you to go to counseling. I want proof that you're enrolled in counseling within the next 14 days. Do you understand that? I'm ordering that you participate in batters intervention programming and attend victim impact camp. Not to possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You understand that?
Okay.
You on a term of 12 months probation. You need to enroll in anger management. You have 14 days to get enrolled. Do you understand that? Did you finish school? Why not? Pull your pants up on your behind. Why not? Why don't you have on a belt? They sell belts at Meijer. Don't you get an employee discount? Get a belt. Don't come in here with your pants hanging off your butt anymore. Not care what underwear you're wearing. You understand that? Why didn't you finish school?
Because I was doing fine, but I had got. Then I had truancy for the same time.
Well, truancy means you're not going. I'm not asking you why. Why did you not go to school? Is what I'm asking you.
And then I had to get computers.
You you didn't know this was during COVID? Okay, well, when the COVID was over, why didn't you go in person?
Like that time, they already passed over to my age.
You don't think you need to finish school?
So,
How are you doing that?
program of Michigan Produce.
You're doing that now? Is that a yes? How far are you into this program?
I didn't start, the classes started until
You need to bring proof that you're starting classes. What you said in September? You need to bring proof to your probation officer within 14 days that you're starting classes. You're not to be in any bars or nightclubs. That shouldn't be a problem because you're too young. You're not to use alcohol, marijuana, or any other controlled substance. Shouldn't be a problem because you're too young, but you are going to be ordered to submit to random preliminary breath testing and urinalysis testing. You have to pay the fee for that, okay? You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You understand that? You're not to engage in any assaultive or threatening behavior. Do you understand that? And you're already on probation for 24 months. Is that correct? You were ordered to complete domestic violence program. Did you complete it? How long have you been on probation? You were to do therapy already, correct? Are you doing it? So you already have all the things I'm ordering you to do.
I just started.
Yeah, but you already have proof that you're doing it. Is that correct? Who's your probation officer in that case? Brandon? You're on probation, and that's for a controlled substance, and they ordered you to do a domestic violence program. Is that correct? I'm gonna waive the oversight fee because you're already on probation. And the terms of my probation may be slightly different from whatever you're doing over there. I don't know. But you're gonna remain compliant on probation, or you're gonna serve a full jail sentence on this case. Do you understand that? I want proof that you're in school, taking your classes, and proof that you are working. You need to maintain your employment, and proof that you are in anger management and in domestic violence counseling. I want proof within 14 days to Brandon Hanna. Do you understand that? I'm waiving discretionary fines and costs. I'm waiving the oversight fee. There's a $75 crime victim rights fee. Plus a $50 state minimum cost that must be assessed. It's $125 that you are ordered to pay on this fine. Do you have any questions? Any additional matters for the record, counsel?
Nothing further.
Thank you. You're all set.
All right. I think we're going to go over to Perkins and see if they recall Big Dummy over there.
So did he need to file advice or rights? I had him fill out one.
Well, not necessarily, because he's already pled. This guy's. Why are you so late?
Okay, does somebody
I
have
was in
a
the room
timestamp for me?
and I didn't know to hit agree there. I just got off the phone with the court up there, and she even agrees that we need better instructions on this paperwork that gets sent out to us. I called at 9. They sent me over to your room because I was in the wrong room, and then I didn't hit agree, sir. I apologize about that, but we do need some better instructions on this paperwork, sir. I was calling my lawyer and everything. I was bugging him. I am so sorry.
Who's your lawyer?
I use a guy named Jim. He's out of Monroe, but he's not in right now. He's on vacation, and I've been bugging him. Yes, sir.
Give me the pronunciation of your last name.
Gambard, Gamburt, and I am a junior, sir.
City of Detroit versus John Gambard. John Patrick Gambard Jr. Case number U717-41325. Appearance for the record, please.
Sharika Harris, on behalf of the defendant, please state your name.
My name is John Patrick Gambard Jr., and I will be representing myself today.
Okay, I apologize.
No, it's okay.
What do you want to do?
I want to plead not guilty, sir, and I would like to make the court aware that I was detained and handcuffed and taken to the police station without being read my Miranda rights. I asked for a lawyer. At the time, my request was ignored. No formal charges was filed at the time, sir, and I was later released. I also believe my car was unlawfully seized, driven by the officers, and impounded without proper warrant or justification. I respectfully request that the court considers these violations, and I'm asking for a formal dismissal or to have a hearing to challenge the legality of the stop and the seizure.
So that's going to be done by a motion. You want to challenge the stop, and so you're gonna represent yourself. You're gonna write your own motion and stuff like that.
Yes, I'll have my lawyer take care of all that after he gets back, sir. Yes, sir.
All right. Well, I'm gonna set a trial date. The trial date will be, because we've already given you a pre-trial date. I mean, this is the date.
Yeah, well, so when I first came in, sir, I'm so sorry. When I first came in, this is my 4th time showing up. I don't know what's been going on, but this pre-trial should have already happened.
All right, well, today is the date time set for a pre-trial. I'm gonna set a trial date for September the 5th, 2025 at 9 a.m. you can, have your lawyer, or you need to get the motion in here before that, and you need to give the city attorney opportunity to respond before that. So generally, the court rules say that you have to give the city attorney 7 days to respond. So,
I just thought, to be honest, sir, I thought it was gonna get thrown out. It was pretty much like they kidnapped me. I don't even understand why I'm here.
but it's not gonna get thrown out like
I really don't.
Yeah, it's not gonna get thrown
Yeah,
out
I
like that.
didn't know, sir.
All right, so you can get your lawyer, or we can appoint, the court can appoint a lawyer for you if you want that. But you sound like you have your own lawyer.
Yes, sir.
So what do you want to do?
So, I would like to also talk to the court-appointed lawyer too, if that's okay, sir.
Well, she just tried to speak to you, but you said you wanted to represent yourself.
I know.
All right,
Well,
join the
I was
break-
so scared, sir. I'm late. It's 11 o'clock. I didn't. Yes, sir.
Join the breakout room. You want a copy
Yes,
of the ticket, Ms. Harris? Hey, give Ms. Harris.
Sure. Thank you.
All right. Wish you the best of luck. Have a very good rest of your day, all right?
Thank you. You too.
You're welcome. That's gonna change your court date to September the 2nd. And that way, I have to make sure that appointed attorney has contacted you. That's what that date is set for.
Yes, sir.
So you need to answer the call. You don't recognize, one of those calls should be that appointed attorney.
Yes, Your Honor.
The attorney has not contacted you by September the 2nd, then we're gonna get one appointed to you on the spot on that day, okay?
Is he talking about a real attorney or like a chili?
Yes, sir. Yes, Your Honor.
More.
All right, if there's nothing further, have a very good day. That's
That's my
next day, is September 2nd, 2025,
Thank you, sir.
8:30. Have a very good day and best of luck to you.
Yes, sir. Sorry about that. Thank you, sir.
All right, very good. Okay.
Okay. Bye-bye now.
Well, it looks like that was the end of the call. Yep. There you have it. We never saw the SovCit recalled. If he pops up later, we'll throw him on another call. We'll throw him on another call. That is the best we can do. All right. I'm out of stuff. Thanks again to Zach and Brecken for helping me out. I will try to put something together. I do plan on doing a happy hour. So hopefully people do some dumb stuff between now and then. I'm confident they will. Thanks for coming out. I'll see you soon.